it meets at its UN offices, as usual in Geneva. The Council is made up of 47 UN member states, which are elected by the UNGA. I think by now you know the 5 organs of the UN, one of which is the UNGA. That's the United Nations General Assembly, etc., etc., and the rest. So the Human Rights Council replaced the former United Nations Commission on Human Rights, which is now defunct and was done away with, as I said, partly because of politics. You have that article with you. Have a look at it. I don't think it's long, it's very brief. Among them were the Universal Periodic Review mechanisms, which serves to assess the human rights situation in all UN member states. So you have another almost dualistic, almost tribalistic systems that are in place. Because here the UN is setting up another system by itself over and above what already exists within the treaty system, such as the ICCPR. Now it has what referred to as the advisory committee, you can see, which serves as the council's think tank, providing it with expertise and advice on thematic human rights issues. Then we have a complaints procedure, which allows individuals and organizations to bring human rights violations to the attention of the council. And finally, the Human Rights Council also works with the UN special procedures established by the former Commission on Human Rights and now assumed by the Council. So basically, these are made up of special rapporteurs. I think you keep hearing of special rapporteurs. I told you we have our former AG having been a special rapporteur as well. Special representatives, we have independent experts, we have working groups that monitor, examine, advise, and publicly report on thematic issues on human rights situations in specific countries. So you can see there's a very strong and deep monitoring mechanism that basically is there, that also more or less doubles up as some kind of enforcement mechanism. Because through that monitoring, you can then follow up to see whether enforcement can then take place. Having cleared that, I am through that system. The next thing I want to have a look at is natural persons, very quickly, and juristic persons. I talked about it, but I want to just emphasize one or two things. Now, you shall notice that our constitution, within the arena of, you shall notice that our constitution, more specifically, I thought I had this constitution open up. Okay, an example, we have our constitution there. Now, when you look at it, it talks about, for example, when you start off with rights and fundamental freedoms, part 2 of chapter 4. Right to life, every person. The terminology used there is every person or a person. We move on, every person, a person. We move on. This is the terminology that is adopted by our current constitution. Every person, a person, a person, every person. So that's the terminology that was used by the framers of our constitution, and that's what they use, especially within chapter 4, that is basically on the Bill of Rights. You will notice the terminology used is every person or a person. Those are the terms that are used constantly. Now, let's go back to what we were dealing with. So several rights, we want to look at now natural persons and just highlight a few things between this and juristic persons. Several rights are phrased benefiting natural persons due to the use of the terms every person or no person. Now, the use of such terms would only be a starting point, basically, for arguing that the rights concerned benefit natural persons. Because that terminology, when you hear it, it shows you that it seems to be tilting towards natural persons. When you talk about a person, every person, no person. So, but that's just the starting point. However, for a clear understanding of the extent of that provision, one usually is required to look a little bit further into the nature and content of the right concerned or the right being referred to, so as to be able to establish that whether it is restricted to natural persons only. So when you use these terms, every person or no person, the first assumption is you're dealing with a natural person, but you're not entirely restricted to a natural person. You will need to be able to look at the right in question to be able to determine whether that right can be applied beyond a natural person to a juristic person, or should actually be restricted to a natural person alone. So, for example, and this is an example from the old Constitution, no person shall be deprived of his or her life intentionally, save in the execution of the sentence of a court, blah, 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 etc., etc. So the use of the term person in this regard would generally include a juristic person, as well as I've already noted, as well as a natural person. But upon further analysis of, now, for example, this right we're looking at, which basically is in relation to the right to life under the old Constitution, Kenya, upon further analysis of that above example, although a juristic person may be said to have life, the kind of life, of course, that is contemplated under Section 71 of the old Constitution isn't the type applying to a juristic person. Because when you look at it, no person shall be deprived of his or her life intentionally, save in the execution of a sentence of the court, and there are many other positions given there. I've just given a small explanation. You realize that this is a situation in which this right is basically referring to a natural person and is not contemplated in its framing to include a juristic person. And so the point is, when terms such as every person or no person is utilized, those kind of terminologies can spill over from a natural person to a juristic person. And therefore, for you to be able to determine whether it also applies to juristic persons will depend on the right in question that you're dealing with and the framing of that particular right and the manner in which it has been framed. If it's framed in a certain way, then clearly you can be able to deduce from its framing that it cannot be extended to apply to a juristic person. Now, the same can also be said under Article 26 of our Constitution, that's the 2010 Constitution, the current Constitution, which also refers to every person. And I think I've been able to show you that. Let me just show you again. In relation to the issue of the right to life, you notice that the current Constitution also refers to every person, and that should be Article 26. Yes. So the right to life, every person has the right to life. The life of the person begins at conception. And so already by the time you go to Article 26, sub-Article 2, and people are talking about conception, then you realize that what you are referring to are natural persons by looking at the scope and the frame and the framing of this Article 26 of the current Constitution. I think I've over-explained that issue. I don't spend more time there. However, this is not always the case worldwide. For example, the Canadian Constitution, not the Constitution, but the Canadian Charter of Rights is more specific in Section 15 regarding the right to life. However, it does this by using the term every individual. And that term every individual goes on further to even reduce the possibility of you contemplating contemplating a juristic person. By that terminology, by that framing, the way in which it's been framed enables or assists you to further exclude the possibility of a juristic person applying to the right in question in which the terminology every individual has been used. Now, juristic persons, very quickly. The use of the term person, as we all know by now, you should know. If you don't, you need to think deeply as to why you don't. The use of the term person may be taken to mean that Some of the rights are also meant to apply to juristic persons because, as I have said ad infinitum, in law, the term person includes both a juristic and natural persons. It includes both these. As I said, that is something that we all know by now. We know that a company is a separate legal entity. Now, recognized in law to have the ability to do a good number of things that a natural person can be able to do. And so companies are basically juristic persons. The law appreciates that and recognizes that. Indeed, some rights would be seriously compromised if they did not apply to corporations as well as individuals. So, for example, corporations, and that's the media houses, if they don't have freedom of the media, they don't have freedom of expression, they don't have the right to property, if they cannot invoke these rights, then these rights then become hollow and unenforceable rights. Remember that even behind these companies can cause significant atrocities. They don't just have rights, but they can also cause significant dangers and atrocities to other natural persons and to other juristic persons. As a result of that, they need to be able to be held liable, and they generally are usually able to be held liable. It follows that if they can be held liable, they also have rights which they may need protected against other natural persons, against other juristic persons, or against the government of the day. That wraps up that area. I have talked about the cases that Royal Media Services, that is Citizen, had to file against the old Moi regime in this particular area, and how, as a result of that, I will highlight that in what I'm going to be dealing with under Article 24 fairly briefly soon. But let me just say it because I may forget. And how that informed the current constitution and its framing to be very clear that you do not necessarily need to have the procedural rules enacted by the Chief Justice for someone to be able to go to court and obtain assistance of the court in relation to issues of human rights. Some of those cases against Royal Media Services and various individuals, basically what ended up happening at the time is, I think it was Chunga, as he then was, Chief Justice Bernard Chunga, but not just him alone. I don't want him singled out on this issue. There were also other Chief Justices who made sure that they never operationalized or came up with procedural rules in relation to human rights. And what would then happen is that when people approached the court, they found themselves stuck, and the courts would simply say, there has been no operationalization of the rules that are required for this court to be able to listen to this particular matter. And therefore, what we then had under that old constitution, and I remember talking about this when we're dealing with enforceability and practicability, we had rights that were paper rights that were listed and existed in the old constitution. But when it came to their operationalization, and that therefore means their enforcement and their practicability, it was not possible to extend those to people on the basis of a mere technicality. The current constitution explicitly indicates that that cannot be a situation that should arise today. Whether they exist or not, whether a Chief Justice has put in place the requisite rules to be utilized in relation to human rights claims, whether they're in existence or not, a court will still be able to listen to any issues in relation to human rights. Okay. Now, let's move to the moral theory and legitimacy of human rights. Now, I want you to be keen in this area. This fairly a bit philosophical, but nothing difficult. You just need to understand the basics and fundamentals around it. Now, the notion of human rights has an innately moral or ethical connotation, as we have seen. As we have seen its relationship to, and I sent you again. If you watched the some of the stuff I sent you last time, you hear this discussion taking place. So we have natural law, we have natural rights, and all these emanate from elements of morality. If you understand natural law and what it espouses, we've talked about that. I'm not going back into it. And so, appreciating that, indeed, it is in the realm of moral theory and discourse that the concept of rights. I'm wondering why my screen is, just give me a moment, it's troubling me. Yes, it's fine. So it is in the realm of moral theory and discourse that the concept of rights first gained its currency. That we already know, we are not repeating that. So in order to understand the nature of a right, it's necessary to have at least some kind of cursory understanding of moral theory. And this is why we are going into the moral theory and legitimacy of human rights. Now, I'm not going to necessarily deal with all the theories in relation to human rights, but I'm going to deal with some, especially the moral theory, which is very important for you to have an idea about. There may be others, such as Ubuntuism, which have a reason, but I'll not spend too much time on those. I'm not going to go to those for now. I may choose to deal with them slightly later in the course. So, to deal with this issue of the moral theories, then we must ask ourselves, then, what is morality? And it's important to understand that morality basically consists of the principles which dictate how serious conflict should be resolved in our lives. That is the appropriate definition of morality in the context in which we are speaking. Morality should not be viewed from the perspective that you view it every day, whereby somebody has a short miniskirt and you think it's immoral. Somebody has put on a tight dress, you feel it's immoral. Okay, that's not what we're talking about. We're talking about serious issues, not frivolous issues that border on cultural differences. So morality will consist of the principles which dictate how serious conflict should be resolved in your life. Significantly serious conflict. Now, when morality applies to a particular situation, what it tends to do is it does so usually in a decisive manner. And what tends to happen is that moral judgments then tend to trump all other types of principles. And for example, what do we mean by that? What we mean is, for example, it's a settled social convention that moral prescriptions can be invoked usually to justify breaches of all other types of standards and rules, whether they relate to norms of business, sport, politics, etiquette, or even law. And we see this all the time when we use moral judgments to trump a good number of other principles. This is to show you the manner in which we view morality in and of itself, and its importance, therefore, in society to some extent. And how do we see this? For example, if you happen to break the law, but you have acted in an ethical manner in doing so, you will not necessarily usually avoid legal punishment, but you will avoid the social embarrassment and stigma that is normally consequent upon legal wrongdoing. And so there are things that you may do and people will support you in the sense that you will not suffer from the social stigma as a result of what you did, because they feel you stood up for an appropriate moral position within that society. So, for example, you will find that a politician, let me move step by step so that I don't move all over the place. So many people are usually prepared to excuse even a murderer who, for example, has euthanized another person but has done it out of compassion. Of course, you will still have people who believe that's an inappropriate thing completely, but you will find that there are people who will be able to excuse you depending on the circumstances and exactly what was happening. Now that it may still have a variety of views, but let's move on. For example, journalists. A journalist who refuses to reveal the identity of his informers, who have tipped him or her off regarding perhaps stories of social importance, corruption, things that are going on in government. These are people who are typically regarded to be heroes as opposed to wrongdoers. And so you may find a situation where a journalist has been arrested and is being told to reveal his sources as to a story that reveals endemic corruption and rot in the military, in the government, in the health sector, in the university, etc., etc. And in fact, that person could possibly be charged in a court of law for having breached one issue or the other in an attempt to make him reveal his sources. And if he refuses to reveal his sources, you will find that people will support him. They will say, yes, we are supporting this person because he has been able to expose a very key issue that members of that citizens of that country were not aware of. Again, that's an issue of morality. People are supporting him. And that's why we're saying that moral judgments then trump, often you will find will trump many other issues. So we do not condemn also the politician who disregards party policy and goes ahead and casts a conscience vote on a morally important issue as well. So for example, VAT, let's assume VAT is supposed to be raised up to a certain point in time. I know this is not always the norm in our country, but we still do have situations where this can take place. And then you come together and say, okay, well, I keep hearing as if there's someone trying to get into this class. Okay, that sound, I've let the person in. So you will find that if a person from the ruling party or a person from the opposition party decides that, no, I'm not going to vote for an increment in tax, Kenyans are already suffering enough, and breaks away from the party policy. And as a result of that, the party wants him punished. You will find that people will still support that particular politician for having taken a position that they feel is morally sound under those circumstances. So you will find it is also permissible to break the social etiquette of queuing, for example, as another and last example, in order to get timely medical assistance to an injured person. If someone comes to hospital and they are profusely bleeding and people have been queuing, and you can see clearly this is a difficult situation, you would often let that person to the front of the queue so that they can be attended to a bit more quickly. And so that is socially, so that's a moral issue. And as much as the social etiquette is everybody must queue, you are going to be willing to let that person go ahead of you. So I think you get the point. I think I've used a number of instances to try and elaborate the same. And so another feature of morality is that it only relates to situations where there's an actual or potential conflict of interest, usually between two or more parties. Remember, we said this is how you resolve serious conflict in your life. So it is used to assess and weigh the respective interests that are going on there. In a perfect world consisting of unlimited resources and where there are no clashing rights, generally you would find that morality would be redundant. Often, morality comes in, and we've had this discussion, I think, previously when we're looking at the history and all that. Remember the words of Paras Diwan around these issues in his book, Indian Constitutional Law, and it comes up again here. We notice there are a lot of things we have in society now that as a result of limited resources. And so we've developed ways to be able to function within the society as a result of that. But without those limited resources, if there are unlimited resources, there's unlimited water, you have less conflict. There's unlimited food, you have less conflict. There's unlimited opportunity for everybody, you'll have less conflict, and probably less reason to regulate people, and therefore less reason for a good amount of moral rules that exist. I know I'm now getting out of, I'm just about to go into whether it's objective or subjective as I finalize on this issue of the moral theories, and we look at the two key moral theories around this. But you will discover many things exist because of limitations, because of limited resources. Even marriage as constructed today is constructed that way partly because of limited resources. Part of the reason why we still function in a monogamous setup as well also has a relationship to limited resources. So many of the rules in society, over and above, even the basic social rules we have, you find are tied to the idea of limited resources. Because then if you don't have those moral rules in place, then you will have a free-for-all society, and it can be very complicated. Again, remember the quotation by Paras Diwan. It makes sense in this context as well. The early man, unlimited freedom of sexual relations, but at a point in which refinement did not exist, unlimited, etc., all that. And so the question that arises then, we've understood morality, and I have said morality is not you wearing a short skirt. Morality is not you, most of the things we think as being the key issues for morality in the human rights context arena and generally are not what we're looking at. Morality is basically how you resolve serious, significant conflict in your life. And so the question as to whether morality is objective or subjective, you realize most people would answer this on the basis of the frivolous things we view as being moral issues, that in the real sense may not really be in the human rights context and generally. So proponents of the view that it is subjective, evolving moral standards over time, and differences in moral sentiments that people have within one culture. So these are the people who argue that is why they argue morality is subjective. A good number of you would, unless you've already come across these theories that I'm referring to, still make the argument that morality is subjective. That is what the proponents of the idea that it's subjective say, that look, there are different moral standards across cultures, and they evolve, they change over time, etc., etc. However, those who believe that morality is objective state that the fact that people disagree about this true state of affairs of a certain matter does not usually necessarily mean that field of inquiry is devoid of an absolute truth. And we see this all the time in science. Just because you disagree about an issue doesn't mean that that area does not have an absolute truth to it. Example, practices, beliefs, and theories in the areas of medicine, engineering, and economics have changed massively over the ages. They keep changing. The way in which construct buildings, etc., etc. Economic theories, engineering, how a car is supposed to move, the various types of cars, whether you can use fuel or a battery, etc., etc. And this keeps changing over the years. You can see now we are trying to move towards batteries and all that. All that is around engineering. When it comes to medicine, COVID-19 is a good example. Differing opinions, some of which were just plain outrightly fraudulent and an attempt to control people. And some which are being denied up to date, which are just basically the truth, but are still denied up to date. And so those big differences in terms of history, in the way in which societies have treated patients, built bridges, and developed market structures and many other things are there. But we've never used that to say or support the argument that endeavors such as medicine, economics, and engineering are not objective fields of inquiry. We've never made that argument, even though people may disagree on how a bridge should be built. At the end of the day, we realize that there are certain fundamentals, certain basics, and that if you don't meet them, your bridge will fail, will collapse. You may use different approaches and some of them may work, but at the end of the day, there are certain laws around engineering, around a bridge, around a car, around medicine, and around economics, that if you don't adhere to, it will fail. And so it remains that economics, engineering, and even medicine, these are objective fields of inquiry. We may not know everything about them, but the bottom line is that over time, as we get smarter and smarter and through experimentation and different approaches, we get closer to finding the truth about certain things, basic fundamental truths. So the truth is there, it exists. However, you have to go through the process of trying to find it. For example, the various ways in which you can build a bridge and make sure it doesn't collapse. So the moment you build a bridge and it collapses and you use the particular approach, it means that one failed. It did not adhere to what is required, because there are other people who will build it in different ways and it will not collapse. It's the same way with the disease. Whatever system you use, if it ends up not curing the disease, it means that you've just not found the truth. But the truth is there because you can find it and find a cure, etc., etc. And so on that basis, we also need to understand that increasingly we seem to be converging around certain moral judgments, certain things that most societies and across all cultures, people have come to accept that these are moral judgments that are accepted across the board. And some of these are, number one, do not kill or otherwise violate the physical integrity of others. This seems to be the position in almost every society. And so you will find that there are almost no societies in which you are allowed to have a situation where somebody has harmed you and you can kill them the way you wish and move on, and the next one kill the way you wish and move on, and the next one kill the way you wish and go on. There aren't such societies really in existence. Most societies have agreed on that. So do not kill or otherwise recklessly violate the physical integrity of others. Number two, do not steal the property of others. This is also something that there seems to be a moral convergence about, not divergence. And this is why we make the argument that actually morality is objective. There are those things that are already acceptable across basically all cultures around these issues of morality. And so there are other things we are still debating about, just the way, like in science, we are debating as to whether you can build a dome that will not collapse without doing certain things, certain mathematical calculations, etc., etc. Those will continue. And so similarly, we are saying that morality itself also is objective. They want to make the argument that it's subjective, and they rely upon these kind of things and moral convergence. The other being, do not lie. Again, we do not find a society that allows people to lie as they wish, completely without any repercussions whatsoever. And lastly, assist others in serious trouble when assistance will be immensely helpful to them at little or no inconvenience to yourself. That's basically the maximum of positive duty, which you should remember and probably we'll talk about later as well. The maximum of positive duty, which basically is assist others in trouble when assistance would immensely help them at little or no inconvenience to oneself. So, as I begin to wrap up this area, these are 4 things that we seem to have as acceptable across all cultures, the entire human race. And these are moral issues. And therefore, to that extent, at that minimum core level, we can say that our morality is objective because we've agreed on these issues. The rest are still issues that we are debating about, and it doesn't mean that we are not going to arrive at a true position, because likewise, even on these issues, we eventually realize that is the only way in which we can function as human beings, morally, in a society. From the period of the early man, we have arrived at the point at which we accept now these 4 are integral in each and every culture and society. And so to that extent, morality becomes objective. And that is how you make an argument around morality being objective. And that is actually the accurate position around morality. That's actually objective in this context. And so now we can look at the moral theories and finalize. What are the main types of moral theories that then exist? They can be divided into 2 broad groups in relation to human rights moral theories. The first is the consequentialist moral theory, and the second is the non-consequentialist or deontological moral theory. Now, we'll talk about the consequentialist moral theories. These are also referred to, and I notice I did not include this here. Let me just add it for you. So you have the consequentialist or utilitarian moral theories. Then we have the non-consequentialist or deontological theories. Now, the consequentialist moral theories or utilitarian moral theories, this comes from utilitarianism, if you're familiar with that particular theory. These ones claim that an act is right or wrong depending on its capacity to maximize a particular ideal, such as happiness. So if you're familiar with utilitarianism, then this should not be very strange to you. Okay? They claim that an act is right or wrong depending on its capacity to maximize a particular ideal, for example, happiness. So for these ones, they decide, the point is for them, an act is morally right or wrong depending upon whether it's going to produce a particular ideal. Often that ideal is usually happiness or the avoidance of pain. It's just put as happiness. So you do something and it is right or wrong depending upon whether it eventually results in happiness. Now, the non-consequentialist or deontological theories claim that the appropriateness of an action does not depend on its ability to produce particular ends, but instead it follows from the intrinsic features of that act. In particular, the extent to which the conduct conforms to predetermined rules. I'll repeat. It claims, this is the non-consequentialist or deontological or rights-based moral theories. I also call them rights-based moral theories. There are 3 terminologies for it: non-consequentialist, or the deontological, or the rights-based moral theories. These ones claim that the appropriateness of an action does not depend on its ability to produce particular ends, but follows instead from the intrinsic features of the act, in particular, the extent to which the conduct conforms to predetermined rules. And which predetermined rules could we be talking about here? In fact, let me not go about it that way. So you look at you can see the two, and you can see the differences. You can see that one is saying something is right or wrong depending on whether it can maximize a particular ideal, mostly happiness. So you decide something is right or wrong depending on whether it maximizes happiness. But the other one says you don't use that metric. It argues that instead you look at the intrinsic features of that act. And in particular, what you're looking at is the extent to which it conforms, that conduct conforms to predetermined rules. And so for non-consequentialist, something is right or wrong depending upon whether by doing it you're conforming to predetermined rules or not. So for example, a non-consequentialist would say, do not lie. That's a predetermined rule of some sort. And therefore, a non-consequentialist will say you can never lie under any circumstances whatsoever. A consequentialist, on the other hand, if talking about this issue of lying, will check and make a decision on the basis of whether doing so will result in happiness or not. I hope you're seeing that distinction that exists between those two. And so, this is the point at which I begin to make certain very key emphasis. And if you are asleep, take this into mind and remember this very clearly. The manner in which we apply human rights is through a non-consequentialist lens, a non-consequentialist deontological or rights-based approach. Why is that so? And I don't want to spend a lot of time asking you questions. That is so because we utilize predetermined rules. The moment you have instruments, the moment you have laws, bills of rights, then those are predetermined rules. And the way in which we have chosen to apply human rights is through the non-consequentialist moral theories, in the sense that we rely on predetermined rules to decide whether what you've done is right or wrong. And therefore, we have rights which we have set down in the Bill of Rights. We have rights which we've set up in various international instruments and treaties, more or less, and you are supposed to adhere to them. If you don't, we say you are in breach. That is the manner in which we apply human rights. We apply it from a non-consequentialist or deontological or rights-based moral theories approach. We do not apply human rights from a consequentialist or utilitarian approach. However, we are going to look and see and note that there may be value in utilizing that approach. As much as we don't use it, we will notice that there could be some sense that exists in that approach. However, let us agree once again that that is not the manner in which we apply human rights. We don't use a consequentialist approach. We use the non-consequentialist moral theories approach. Therefore, the main difference between consequentialist and non-consequentialist moral theories is the emphasis that they give to consequences in determining whether an act is morally sound. I've already talked about that. Consequentialist theories look solely towards the effect that the conduct has on human flourishing or happiness. Whereas this is at best a secondary consideration in relation to non-consequentialist theories. So the non-consequentialists look at that at a secondary level. The first thing is there is a rule. Is there a rule? Yes. If the rule is there, you must adhere to it. That's what they use to determine. And then later they can consider these other issues. For example, some non-consequentialists would believe that it is always wrong to lie, as I was giving you that example. Whereas a consequentialist would perhaps say lying is permissible if it would produce good consequences. For example, saving someone's life. Now, at that point, I want to delve into one or two things around this area. So you can be able to then see how that works. What I'm going to later on do is I'm going to tie those theories to Article 24, which is what I'll start off with Article 19, and then I'll go there to Article 24, which are key areas. Then I'm going to tie these theories and how these theories can apply. And what I'm also going to do is I'm going to tie these theories and then ask you to be able to have a look at them and ask yourself the extent to which, if applied in a certain way, they make sense or not. That's what we'll be looking at. And so let me move on from that point. By having a brief discussion around some of the problems that arise from non-consequentialist theories and why human rights prefers to be applied from a non-consequentialist approach. Why is it then that we apply human rights from a non-consequentialist approach? What's the problem that's there with consequentialist moral theories? What challenges could be there? We want to have a look at a few. Now, and I did not give you this phrase, unfortunately, but I know how I'll tuck it in for you later. There's a phrase I wanted to give you, but I don't think it's on the PowerPoint. But let me just read it out, and then I'm going to discuss it a little bit. It will enable you to understand what I'm talking about. They're just a series of questions. Now, when we look at the approach we use for human rights, that is the non-consequentialist or deontological approach, we've said that's how we apply human rights. And we've said that there are certain problems that are there with the consequentialists. That's why we don't use them for human rights generally. I said I'm going to look at a few of those problems. But before I look at those problems, it's also important to appreciate that these non-consequentialists, while that is the approach we use, they also have some challenges. So for example, they seem not to give convincing answers to certain central issues at a philosophical level. I will repeat what I was saying, and I hope we're together. I said we apply human rights from an unconsequentialist, deontological, or rights-based approach. Why? Because we adhere to rules. Where these rules, we've set them out in treaties, okay, bills of rights, various kinds of charters, and acts of parliament. Not just in Kenya, I'm talking generally. There are countries that have acts of parliament for human rights. And so that's the manner in which we apply human rights. And we felt that's the best way to go about it. And we say we do so because consequentialist moral theories or a utilitarian approach in which you decide on whether something will make many people happy or not is not necessarily the best way of dealing with things. I have said I'm going to look at some of the problems with that consequentialism very soon. However, I said before I do that, as much as we use the non-consequentialist approach, and it's a better approach for application of human rights and getting uniformity, a uniform approach because of the international all that to applying human rights, there are some challenges with it. The first challenge with these non-consequentialists, before I go to consequentialism, is that they seem not to provide convincing answers to central issues, such as, number one, and I think this I'll have to just write for you, it's not there. What is the justification for rights? Okay, so this is a challenge with the non-consequentialist approach. While we use them, they still have this challenge. They don't seem to give us what the justification for rights is. Number two, how we can distinguish real rights from fanciful rights. At that point already, something should click in your mind around the kind of challenges we are having currently, the discourse we are having currently with our deontological approach of rights. And that split you can see between Western countries, African countries, and other countries around certain rights that we seem not to be able to be in agreement with. Again, how we can distinguish real rights from fanciful rights. So this approach we have been using has this challenge. And I said the key thing around this deontological approach is, just put this here. Give me a moment. This is where we are. So just for those of you who are following and maybe you want to check down something, I realize I failed to include this. So we've said rights-based theories or deontological or non-consequentialist. Moral theories, on closer examination, do not seem to be able to provide certain convincing answers to central questions. This is the challenge with rights-based theories. One, what is the justification for rights? And I'll go probably into that next week, although I'll mention that today. Two, how we can distinguish real rights from fanciful rights. And as I was telling you, you can see this challenge playing out right in front of you in terms of the discourse and disagreements we have in different parts of the world around these issues. And lastly, what right takes priority in the event of conflicting rights? What right takes priority? What right takes priority in the event of conflicting rights? Those are the three issues that we find we have a challenge with around the rights-based theories, the deontological or the non-consequentialist approach to moral theories in relation to human rights, which I said is the approach we use for human rights, because remember we have a system in place. And one of the reasons why we do that is because it at least enables some uniformity, okay? Whereby we have treaties, we have instruments, and we agree on what we feel should be the way forward, including a number of other reasons. But it doesn't seem to give an answer to these three central issues. And I want to quickly explain how this is the case, although I may go into this a little bit more next week again. The first one, what is the justification for rights, is problematic from a deontological approach, because this so-called justification for rights seems to primarily be that of, the answer that is given here seems to be dignity by the rights-based approach. The answer it seems to give here is dignity. However, dignity ends up is usually, and I'll deal with the critique of dignity next week, it's a dualistic concept. And so we are not saying that this is wrong. We're just engaging in a further examination around this entire issue. We're saying, yes, it's fine. This is what we use. But what challenges are there within it. We've identified 3 central challenges and noticed that it doesn't seem to give upon closer examination, it doesn't seem to give convincing answers to some things as much as we use it. And we're identifying, the first one is, what is the justification for rights? And we're saying it seems to answer that as being dignity. Yet dignity upon critique doesn't seem to be an adequate foundational justification for rights. When looked at more closely, we will look at a critique of that. So that doesn't say we don't use it. That doesn't say we don't recognize it. We're just critiquing the same. I hope we all understand what a critique is. And number 2, how we can distinguish real rights from fanciful rights. And I've said that's a problem. You see this discourse going on. Some people feel certain rights are really not rights. Others say they are. And so we are in this constant discourse or loggerheads around this particular issue. And the rights-based moral theories do not seem to be able to give us a convincing answer as we've criticized it for. And number 3, what takes priority in the event of conflicting rights? Also, it doesn't seem to give a proper convincing answer to this. It simply states often, as most of you would say if I asked you about a challenge between a right between you and another, and the way in which the court tends to use it, is that your rights begin and end at the point at which they begin to infringe another person's rights. There isn't a very adequate, proper explanation behind it. And so those are criticisms. And therefore, we acknowledge it's not perfect. It is what we use. It works well. It's rational. It enables uniformity. It's the way in which we apply rights. And it's the way we will continue to apply rights. However, while acknowledging that, we can also critique it, because that is the part in which one is supposed to be able to have adequate knowledge around an issue. And so your argument cannot be and shall never really be within the arena of human rights that we should not use a rights-based approach. But if you were to be asked the challenges that the rights-based approach has, or while engaging in a discussion, you should be able to identify some of these things I've just mentioned here as being some of the challenges that this approach has. Not that therefore we should change and go to the consequentialist. No, we shall continue to use this. It is the accepted modus operandi, but those are the challenges that it seems to have. It is okay to use a system or an approach, but be aware of some of the challenges it has, because then we may be able one day to come up with a better or convincing answers to these kinds of issues. I trust we are together at that point. And so I'll finish by looking at some of the challenges that people have raised as being some of the problems with utilitarianism or consequentialist approach, or utilitarianist or consequentialist moral theories or approach to human rights, and why this approach was generally rejected and is still not really used. But we shall see later on that there's a way in which sometimes it seems to still be applied, especially in an attempt to answer the last question here: what takes priority in the event of conflicting rights? Okay, it's applied in a way in which people don't seem to realize it is, but that's neither here nor there. So the first main criticism around this is that it fails to protect individual interests, such as the rights and integrity. It fails to protect basic individual interests, such as rights and integrity. Because, and I hope you've taken that down some if you so wish, I'm not going to spend a lot of time on that, just one or two, mention 2 or 3 problems. Because you see, it seems to concern itself with maximizing the ideal of happiness, which means if happiness can go to the greatest number of people, then that's it. So we are not going to be concerned with the rest. It's an almost majoritarian approach to looking at things. And so because of that, it is criticized. Because remember, human rights in and of themselves come into existence and often try to safeguard the rights of an individual in terms of his rights and integrity. We've talked about this before. so that you then do not become a slave to group issues. And you can be looked at and viewed as an individual in terms of what you may prefer as an individual. And so that's one of the biggest problems with utilitarianism, if it was to be applied as the approach or the way through which we should view and apply human rights. We use those theories as being the way in which we should apply human rights, it then can lead to that kind of difficulty or absurd outcomes. Another criticism, which is related to the first though, but still a criticism of utilitarianism or the consequentialist moral theories, is that it cannot protect any individual interest as such, because it seems to be more concerned with the majority of the people and how they can feel happy. And lastly, is that this concept of happiness or any other particular ideal is too vague and imprecise to give proper guidance to moral issues. I'll repeat the last one, is that the concept of happiness is too vague and imprecise to give guidance to moral issues. So those are the three criticisms, and you can see they are quite significant, because if they are left to apply in a certain way, then it becomes difficult. Then human rights again ceases really to be something that sometimes is required to safeguard the individual adequately. And so that remains a potential challenge and a potential problem with consequentialism. So we've looked at that, and we've looked at both, basically, a critique of both, and we can note that as a result, the world generally has opted to utilize the non-consequentialist approach, despite some of its challenges. Now, at that point, I will ask, is there any question before I now tie this to, as I move on to Article 19 and the rest? Is there anybody who has a question around that? Are we together? We understand both the theories, we understand how they work, we understand their criticisms, and we understand that the theory that is utilized for application in the arena of human rights, which is the deontological or non-consequential or rights-based moral theories. Okay, I don't hear a question, so let me wrap up then with my issues for today. Keep that in mind. I think I will still have probably a 10-15 minute discussion tying it to other areas next week that we'll be dealing with next week. But for now, I'd like to transcend on and leave the issue of a critique of dignity. I will deal with that next week, which is a very short thing, a 5-minute thing, and tie up some loose ends around the moral theories. I would like to move on to particular articles. Specifically, I will tell you, you need to be able to have a look and read the entire Bill of Rights, but more specifically, in order to be able to understand the operationalization and enforcement and various prerequisites and rules around how human rights work within our domestic context in Kenya, you need to have looked at Article 19 to Article 25 very well. I'm going to look at Article 19. I'm then going to have a look at Article 23, and I'm going to have a look at Article 24. That leaves the rest of them, I think, to 20, 21, 22 to you to have a look at. It doesn't mean they're not important, but I'm focusing primarily on these for a particular reason. And when I get to Article 25, I'll then tie it to those issues we've just discussed around the moral theories and how that Article 24 can relate to those particular moral theories, the disconnects and etc., etc. And that will then mark the end of my lesson. So probably another 15, 20 minutes, I'll be done. Now, rights and fundamental freedoms, Article 19. So 19.1, this is pretty basic. It sets a basis for human rights and the Bill of Rights. It introduces it somewhat. And so the Bill of Rights is an integral part of Kenya's democratic state and is the framework for social, economic, and cultural policies. So it's already setting a framework. And so that means that in Kenya, if you're going to come up with socio-economic and cultural policies, they need to be based upon the Bill of Rights. 19 Article 2, the purpose of recognizing and protecting human rights and fundamental freedoms is to preserve the dignity. Now, again, there it is. There is the word dignity. And now you begin to see or understand what I was talking about. We applied rights from, as I said, a non-consequentialist rights-based approach, because we are working with predetermined rules. Our constitution obtains or comes up with our Bill of Rights partly and significantly from the international framework. So these things were set up at the international framework. You know the timeline, and you can go as far back as you may wish, beyond the Second World War, if you may want to do so. But you notice that these rights at the end of the day were anchored after having been established and placed on various documents on dignity as being the foundational principle. And therefore, it is not surprising that one of the first things you come across is that, and the article will say just as much. So bear that in mind later on when we look at some critique of dignity. So I'll repeat for the 10th time, it does not mean dignity does not exist. We are just going to engage in a slight critique of it. So the purpose of recognizing and protecting human rights and fundamental freedoms is to preserve dignity. So that is the purpose for why you are even protecting and recognizing human rights. It's a foundational principle from an unconsequentialist approach of individuals and communities, and to promote social justice and realization of potential of all human beings. Again, when you see that, it brings and introduces that individuality that we say is missing when we take a consequentialist approach. Number 3, the rights and fundamental freedom in the Bill of Rights, A, belong to each individual. That element of individuality is very important and are not granted by the state. They're due to you for being a human being. B, do not exclude other rights and fundamental freedoms, not in the Bill of Rights, but recognized or conferred by law, except to the extent that they are inconsistent with this chapter. And that can come in relation to that difficult discourse around LGBTQ. And then C, are subject only to the limitations contemplated in this Constitution. And so, in fact, let me get an answer. What are some of the most evident limitations contemplated in this Constitution in relation to rights that may exist in other jurisdictions but don't exist? We have said don't exist in this country. Then you can think of one or two. They should be pretty easy. There are certain obvious limitations in our Constitution with regard to rights that exist in other jurisdictions that people can engage in other jurisdictions, but we have rejected and expressly perhaps so in our Constitution. Which are these? Anybody? I don't know that I'm teaching a class today. What's going on? I hope you're there, you're listening, and I hope this is not difficult. I think you can be able to think up many things that are illegal in other countries that are not legal here from a rights perspective. Anybody? Yes, Sarike, let's give it a try.
Yes, so I would say the right to found a family. So it's not provided as a right, but in our Constitution, it's that right to every person has the right to marry a person of the opposite gender. So we kind of limit that right, whereas there are some jurisdictions that do not necessarily provide for that, that it has to be just of the opposite gender. I would also say in terms of reproductive rights, abortion rights, we also limit that whereas there are some jurisdictions that do not necessarily limit it or do not limit it in the way that we do. Let's say, for example, in Germany, they limit abortion only up to I think it's the second trimester, but for us, we limit it in another way where it's defaultly it's illegal unless then there are some circumstances that force you to have it.
Okay, thank you for that. At least I can see some of you are at least with me, or most of you are. That's the position, and she has put it very well. I don't even need to add anything more there. Those are some of the two key areas. You can think of others. Reproductive rights. Abortion is legal in some societies in quite a broad way. We limit that. Abortion is basically not legal except in certain circumstances as indicated in the Constitution. And so you can see that our Constitution caters for those kind of issues by that provision within Article 19 already, being able to show that. There's also the issue of basically the marriage issue. We restrict it to genders of the opposite sex. That's going to have a problem at some point if this madness of gender fluidity that actually has its roots, very sadly, has its origins from radical feminism, finds its way, because it's based on social construction. And radical feminism was of the opinion basically that the only reason why people have decided that women should perhaps handle certain things domestically and in the state of nature is because of the patriarchy, and has got nothing to do with their sex. In fact, that obsession of separating gender from sex has now been the byproduct of what we are seeing taking place in these other societies, in which the moment you say that gender and sex have zero relationship, which is what has been espoused for a very long time by social constructionists, the moment you do that, then it becomes impossible for you to tell somebody who tells you that they're a man and they feel like they're a woman from telling you that, because after all, gender is a social construction. It's a very interesting thing, but that's beyond your scope. At this point, it came to mind, and that's going to be a challenge to some of these provisions eventually. Once they find their way into this jurisdiction, if they ever do, we will actually have to enact laws to deal with those kinds of things. But that's just as a by the way. Don't pay too much attention to that. That's beyond our scope currently. And so I think I've looked at that, and you understand that. Article 19. Now, Article 23, a couple of things. I would like to finish this bit today. So authority of the courts to uphold and enforce the Bill of Rights. So enforceability, you really have to be able to think about it from an international framework perspective, explain that well from the IBR to a few other systems that exist within the UN and other treaties, perhaps one or two, and also be able to explain how it is domestically within our constitution, and also be able to explain how it is regionally. And so for us, our enforcement is here. And although I'll expand on this maybe a little bit later again. For example, the High Court, we know, has the jurisdiction in accordance with Article 165 to hear and determine applications for redress of denial, violation, infringement, blah, 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 of the Bill of Rights. So you can already see we have a judicial system there. Commencing perhaps from the High Court to deal with these particular issues. 2, Parliament shall enact legislation to give original jurisdiction in appropriate cases to subordinate courts, blah, blah, blah. So this can be extended to subordinate courts through the requisite legislation. 3, in any proceedings brought under Article 22, a court may grant. So you need to have a look at that. That's why you have to look at that entire area. So these are some of the reliefs you can be able to obtain. Okay, which really is an issue around enforcement. These are some of the reliefs you can be able to obtain. A declaration of rights, You can be able to obtain an injunction. You can also be able to obtain a conservatory order and a declaration. And there are multiple cases in which this has taken place. You can also be able to an order for compensation. You can also be able to obtain judicial review. I tend to refer to it as the mongrel application, in which one you seek both judicial review orders and you also are seeking infringement of constitutional infringement of the Bill of Rights. Some of you will come across such applications later on. And so that is Article 23, an element of enforcement. And it's not just 23 alone that deals with enforcement. There are other elements of enforcement you see throughout the Bill of Rights and in the Constitution in general. So let's move to Article 24, very important. This is now limitation. Now, this is very important in relation to those theories we're talking about, and I want to wrap up that fairly quickly. So limitation of rights and fundamental freedoms. A right of fundamental freedom in the Bill of Rights shall not be limited except by law, and then only to the extent to which the limitation is reasonable and justifiable. So you can't just limit, you need to limit by law in an open and democratic society based on human dignity, equality, freedom, blah, blah, the rest, including the nature of the right. So these are the things to be taken keenly into consideration. The importance of the purpose of the right, the nature and extent of the limitation. These are things that all need to be able to be adequately there. The need to ensure that the enjoyment of the rights and fundamental freedoms by any individual does not prejudice the rights and fundamental freedoms of others. This is what we talked about. And this is what I told you about when we were talking about the deontological approach. And you can see it prescribed as a potential solution. And so it is fine. There's nothing wrong with it. However, in practice, in actual practice, it becomes problematic because it is applied, and then along the line, you notice that the logic sometimes veers off to consequentialism. The relation between the limitation and its purpose, and whether there is a less restrictive means to achieve that particular purpose. So look at Article 24. I want to go to the areas that are more important to me in regard to this article, which I'm getting to just now. So despite Clause 1, a provision in legislation limiting a right of fundamental freedom may, as listed from A to, I think should be D, in the case of provision enacted. So please have a look at this. Just read this, and I want to basically deal with the gist of the whole issue. Around the whole issue around Article 24. The importance around Article 24 is it sets out the parameters or the ways in which you can be able to limit a right. It's basically that simple. You, however, need to be able to understand the specifics. It's not a long article, it's very basic. And especially when you look at, for example, you look at sub-article 5, whereby you see all these issues having been listed. More specifically, a provision in legislation may limit the application of the rights of fundamental freedoms in the following provisions to persons serving in the Kenya Defence Forces. So there are individuals who may still have this certain particular rights limited. Those in the Kenya Defence Forces and National Police Service. Article 31, privacy. Article 36, freedom of association. Article 37, assembly. Labor relations, for example. So you are not expecting to see members of the Kenya Defence Forces going on strike. There is a limitation to some extent in that regard. And so you can see all that. And so look at Article 24. It's the reason why I've talked about it. It shall shape the way in which you understand limitations, the way you can limit groups of people who their limitations may work in a certain way. Again, look at sub-article 4. The provisions of this chapter on equality shall be qualified to the extent strictly necessary for the application of Muslim law before the Qadi's court. And so you know that is, so you need to be able to bring out these kinds of issues to persons who profess the Muslim religion in matters relating to personal status, which basically is marriage, divorce, and inheritance, and burial, by the way, which is not included there. strangely, but yes, burial also is a matter of personal status. I think you know there are communities that have these challenges, and nowadays it's spread out. It's not even just Western and communities in the western part of the country that have this challenge, this problem. In fact, we have a notorious case now in Kiambu, where the guy, they just refused to bury him because it was going to lower the value of the land. And I think he's now surpassed Anyona, who was the one who I think had done 1 year and a half or something without having been buried because of a burial dispute. So the burial disputes that are now emerging in other areas are economic in nature or a bit different. And that's not my topic here today. I sometimes veer off. The point is, I think you understand this. You're lawyers. I don't need to talk to you about issues of personal law and that kind of thing, and the extent to which, in fact, the hierarchy of laws under the Judicature Act. I think you know how that is, and you know what the Qadhi's Court can do and apply. But you need to understand in the context where both the parties are of the Muslim religion and have agreed to be subject to the Qadhi's Court. Then you don't go there shouting aspects of equality under the Bill of Rights, because that means you've accepted to be governed by a different set of rules, which has been constitutionally recognized, which you can choose to opt out of if you so wish, which would immediately take you to the High Court for those succession matters, and then supersede the Qadhi's Court, not as an appeal, but just as a, it's done either as a transfer, or there's also another procedure you can use in that regard. So that's Article 24. Please look at it, understand those dynamics. Article 25, which is now the last thing I'm dealing with today, and I want to now tie it to those theories again, together with Article 24 as I finalize, is Article 25 now sets down what we refer to as fundamental rights and freedoms that may not be limited. These are non-derogable rights. The other terminology for them. Don't go see non-derogable somewhere and you start wondering what is this. So non-derogable, it means you cannot limit these rights. I've talked about this before, and I will talk about them again fairly quickly. They are 1, 2, 3, 4. The first being freedom from torture and cruel, inhuman, or degrading treatment or punishment. This was derived and picked straight from international law. It is basically international, almost basically customary law, and has been accepted internationally. It is already accepted internationally that you cannot create exceptions for torture. Now, I would like you to think about that statement internationally, how it's accepted within international law, how we've picked that and brought it into our constitution domestically, and then ask yourself what happens in practice. Not just among countries that are not well known for safeguarding human rights, but even among countries that are the so-called bastions and propagators of human rights. And then ask yourself why that disconnect. Now, this takes us to what we were talking about, the ontological moral theories. You're supposed to adhere to it, predetermined rules. You're supposed to adhere to it. But why do you find some nations struggling with this? Is there any way, if I asked you such a question, would you be able to utilize these moral theories we've just talked about in the context of Article 25 in general to explain that away? And part of the way in which that would be explained is, you know very well, we apply, you would go through the moral theories, you would explain them, you would explain the deontological, rights-based or non-consequential, and say that's what we use, that's what we apply. They are founded on dignity. I'll explain that well. Then you move on further and identify in this list, for example, this. And then subsequent to that, now, after having explained that well, explained that's how we're supposed to operate, then you need to explain now that disconnect, why some countries still do what they do, and what may inform that position, and how that is related in certain ways to consequentialism, and why it is those countries find themselves in a situation in which they feel that they have to now then engage in that, despite what is clearly evident and in the law. Freedom from slavery or servitude. I think this is the one that, as well, slavery was outlawed long before we even have the current existing instruments. We talked about this and I explained this as well. So that's another one. The right to a fair trial, which is very interesting. And some of you can litigate around that. What is it exactly that constitutes a fair trial, and at what point can you say that your client actually obtained a fair trial? And of course, the last one, which is the right to an order of habeas corpus. This is mostly a Kenyan thing, and I'm not saying it doesn't exist internationally in other places, but this was informed by, remember, always ask yourself the historical underpinnings of why we have the things we have in our constitution. Why is it that we have a whole entire chapter on devolution consisting of more than 20 articles in Kenya? It's because of our history of mutilating not only laws, but the constitution itself. And you can see we recently were trying to do that again. Why is it that our constitution is very difficult to amend, and you had the constitution? Because of our history. Now, this the right to an order of habeas corpus being included as an underogable right in Kenya and our constitution is also based on our history in relation to issues of torture, disappearances, assassinations. And so you want to place a very onerous burden on the government that when you ask them and you go before them with an order of habeas corpus to produce somebody, they better be able to. That's the historical foundation around that. I thought I'll just mention that. Now, having talked about that, I now conclude by stating this, that Article 25 is a good thing. We accept it. As we said, we apply the law through a rights-based approach, but there are challenges that can arise. And those challenges arise in the practical, everyday real world. And that is one of the biggest challenges that exists, because you will find that these things are here, they are placed, we are supposed to adhere to them, but for some reason there's a disconnect. This disconnect perhaps indicates a gap. That gap takes us back to those challenges that may exist with regard to rights-based theories. And sometimes you notice that when those gaps come into existence, we realize at that point that perhaps, just perhaps, consequentialism can fill in that gap. But as I said, that is not the way in which we apply human rights. But when that gap exists, you very quickly notice that consequentialism and its rationale is what has been used or what can be used to explain away those challenges. But because we must find a way of being able to move forward in application of human rights, we will always apply rights from that approach. That is the deontological, rights-based, and consequentialist approach. But as you know, there's a disconnect between theory and practice. Just the way some of you, if your girlfriend asks you if she's fat, I'm sure, or your wife, I'm sure, your answer is not is often not going to be, in fact, yes, you are extremely and very fat. Your answer is likely to be some watered down, extremely watered down version of that. Because you know that you may suffer certain consequences and deprivation of certain benefits if you happen to go too directly in that way. Of course, there are people who don't mind. There are people who are straightforward, straight talkers, yes, but that still remains the minority. So I hope you understand roughly what I'm saying and what I've talked about, and I hope it's not something difficult. You just need to understand how we apply rights. I don't ever want to hear somebody saying that I taught them that they should apply rights from a consequentialist approach. No. That's not what we've said. We explained both. We've just pointed out that when the rubber meets the road regarding some of these issues, especially, for example, Article 25, and Article 24 for that matter, then you find that we don't have a clear, a gap appears in our deontological approach, and then we realize that apparently that gap seems to be able to be filled more logically by a consequentialist approach. Because if we look at things like torture, one of the reasons why you may find somebody engaging in torture, given a hypothetical scenario, somebody has been abducting girls, he's kept them in a room for a long period of time, and they're dying. But he has refused. You arrest him, you find him with the clothes of the girls, you're almost 100% sure this Muzungu is the one who's been abducting these black girls. And you know that the rest are locked up in a container somewhere, they're going to die. In another probably 8 to 24 hours, they'll be dead, they'll run out of air. So what do? Do you sweet talk him to give you the information, which is what is expected of you? At what point do you make the decision to go in a different direction? And has humanity over time made that decision to go in a different direction? For example, during World War II, when the British were able, for example, to decipher the telecommunication equipment of the Germans, and for the first time, they were able to get information as to every place where the Germans were going to bomb. And the day they deciphered that information, they discovered that the Germans were about to unleash around 5 to 10 bombings in certain particular areas in London. But then they were going to be able to have a whole month of gathering information that would enable them to eventually completely win that war. So they had to make a choice. Sir Winston Churchill and these people had to make a choice. Do we go ahead and counteract these people as they come to bomb these 5 to 7 places? Which if we do, they will know we have deciphered their communication and they will change the codes and the channel, which means we will never be able to know more and we'll only have prevented this one attack. Or do we go ahead and wait, let them bomb these 5, 7 places, and then after that, in 1 month, we will have gathered enough information to completely paralyze these people completely and perhaps be able to win this war? What do? You can guess what they did. They waited. That is pure utilitarian consequentialist calculus. And so that is my point. That is the challenge that sometimes arises with regard to these particular issues. And it's important to be able to understand both and understand the rationale as to why we go the way we do. We go the way we do because it's important for individuals, it's important for uniformity, it's important for a large variety of issues. But sometimes, especially in the context of things like Article 24 and 25, when we are engaging in the realpolitik and the reality of things, then we see gaps sometimes arise. And when we ask ourselves, why this gap? Why does America have Guantanamo Bay? Why did it have Guantanamo Bay for all that long? Then you realize at that point that there's some utilitarian calculus that has come into existence. Or when the court needs to make a decision about an issue, then it plays around with what I showed you in Article 24. Plays around and moves around, trying to move between one person and the other. Article 24D, the need to ensure that the enjoyment of the rights and fundamental freedoms by any individual does not prejudice the rights and fundamental freedoms of the others. Where does that begin and where does that end? Where is that line sometimes drawn? That's when we begin to again find challenges with things like dignity, which is the foundation for this, with things like where you draw the line of where that right begins and where the other one ends. And then you discover that eventually, while applying this, you've engaged in some utilitarian calculus at the tail end. For example, to finalize this class, I think I have 2 minutes. The case of conjoined twins, A and B. You have twins who are conjoined. And the question that arises then, when you have conjoined twins, sometimes one of them is parasitic as opposed to symbiotic. If it's a parasitic relationship as opposed to symbiotic relationship, we therefore mean in that situation that you will find that one of the twins, for example, may be the one who has most of the functional proper body organs, while the other who is conjoined to this particular twin may actually be one who feeds off the other more and has less organs, is surviving on the other. And therefore, what happens is after a period of time, there's a probability these people will not reach a certain age. And there you are as a parent. You then have to make a decision. These are all human beings. They're born. They have rights. How are you going to make a decision? Most likely, you're going to make a decision if you choose. Some people choose not to make decisions, as I've always said, the way some of you choose not to take positions on issues, and we all do, just some of us do that more than others. And this is why we said morality is not these frivolous things, it's how you resolve serious conflict in life, such as the ones I have given you illustrations on. So these are your children. What do you do? If you cut off and make sure that one of them continues to have the main organs and deprive the other one will probably die after a week or 5 days or less, a couple of hours. But the other one will now be able to have a long life. But if you leave them together, then they have been given a lifespan of maybe 7 years or less, 5 years. Then they shall both die. And you've gone to court and you're battling over rights. The end of the day, you will realize, while that person is talking about this individual, where the prejudice of one as far as the other goes, when you examine it properly, you discover that utilitarian calculus has been applied in resolving that clashing right. And that's why we said one of the weaknesses of the ontological rights, it does not seem to really have a proper formula or calculus for resolving clashing rights. I think I've talked over and over about that. I had another example, but I think because I will start off with the critique of dignity next time in our class, before we now move on to cultural relativism vis-a-vis universality, which I will clear as well next week. That will then open up the avenue for me to introduce the specific rights. I'm going to go through each and every specific right that I can, focusing more on freedom of expression and a couple of others. I don't know if I've sent you that on freedom of expression, the rationale for it. So I'll deal with I'll leave it at that point. I'll probably give you another illustration around that next week and then transition that. So I've tied this and explained how those moral theories relate to these articles of the Constitution, how they relate in real life. And we've now been able to look at that. Is there any question? I think I'm done for today. Next week, I deal with moral theories, and I start off on some of the rights as well. Any question? Okay. Okay, I hope you're together, and I hope by this juncture, as I'm beginning to now think about releasing an assignment for you to you guys, which I will do towards the tail end, probably in May. So even if I say that now, because I believe the examinations should be the last week of May, I should confirm that. Should be commencing then, around 22nd. So probably early May. I'll see when we're able to release that. Please begin to have a good understanding of all we discussed. First generation rights, second generation rights, third generation rights. You know all those things, which rights are which, blah, 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 etc., etc. Familiarize yourself with this and how to be able to apply, because your questions will be application. So have an understanding of what we've been dealing with. All the best. Have a pleasant week.
Thank you, sir.